her because we had issues with drug use. And nobody can help anybody who doesn't want to be helped. She was here December 2024 for a violation of condition number 4, not reporting, disappearing.
Welcome back to the docket. Today, the court calls State of Texas versus Alicia Rubio, a community supervision case hanging by a thread. The charge? Assault on a family household member with a prior, and a 4-year probation term set back in 2022. But here's the turning point. The state says Alicia missed a felony drug court evaluation in January 2025, a direct hit on Condition 39. She pleads true, which opens the door to the judge revoking and sending her to prison for up to the original term. Defense is asking for help and treatment. The state wants accountability. Question is, will the court see progress or a pattern? Watch how fast this escalates.
Alicia Rubio.
Person ready, Your Honor.
Court is calling 2022 CR 3602, State versus Alicia Rubio. Could I have parties announce?
Rick Payne for the State of Texas.
Sharon Thorne for the defendant.
And are you Alicia Rubio?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alicia Rubio who was placed on community supervision in 2022 CR 3602 for the offense of assault family household member with a previous conviction on June 30th, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, violation of condition number 39. On or about the 3rd day of January 2025 in Bear County, Texas, the defendant, Alicia Rubio, who then and there failed to attend felony drug court evaluation in violation of condition number 39.
How do you plead to that? True or not true?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition 39, the court could find it true, grant the motion, and sentence you to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes.
Let's decode what just happened. By pleading true to violating Condition 39, failing to attend the felony drug court evaluation, Alicia effectively concedes the violation. That gives the judge the legal footing to grant the motion to revoke and impose a sentence up to 4 years, the original exposure tied to the community supervision case. Notice how the state waived remaining violations, a common tactic when one violation is enough to revoke. Defense is pivoting to treatment over prison, proposing added conditions like DF and aftercare, but the judge is signaling this isn't Alicia's first rodeo on revocation. For viewers, would you weigh missed treatment as proof someone won't engage, or as evidence they need a higher structure program?
Court will find violation of condition 39 true. Is there a proposed agreement?
There is, Your Honor. That is to deny the motion, alter and amend the defendant's probation conditions to add DERF followed by DERF aftercare.
That is our understanding, Your Honor.
Why should I do that?
Your Honor, my client definitely needs help. She's had a lot of mental health issues and depression. Her father died, and she just basically didn't even get out of the house and did not follow any of your terms of probation, but she does want help, and she needs the help. And the state and probation wants to help her, so we are asking you to do that.
All right, so this is not the first motion to revoke she's had with me. Has she done anything on probation?
She's done some community service hours.
In all my community service.
Other than that, I don't see much. A lot.
All right, probation, what has she done?
Judge, I would have to look into the community service hours part of that. But the only thing that I have that she has completed was basically her TAP evaluation. She did her DNA testing, and there's a $90 credit on the account.
Here's the context that matters. Back in December 2024, the court denied the previous revocation and gave Alicia multiple off-custody chances, a TAP evaluation, a mental health evaluation, and a referral to felony drug court, all designed to meet the exact problems everyone says she has: substance use and depression. The judge's message now is blunt. I already tried to help you. And the record reflects Alicia disappeared and has been missing since January. That's devastating for credibility, because without reporting or testing, the court can't verify sobriety or compliance. Defense points to grief, depression, and some tasks allegedly completed. The state points to non-appearance. Quick pulse check. Does repeated non-compliance outweigh personal hardship when a court already bent over backwards?
I mean, she hasn't done anything, and we've been here before. And the court recommended felony drug court for her because we had issues with drug use. And nobody can help anybody who doesn't want to be helped. She was here December 2024 for a violation of condition number 4, not reporting, disappearing. I denied the motion, alternate amended conditions to include a TAP evaluation, out of custody, a mental health evaluation, out of custody, and a referral to felony drug court, out of custody. And then she disappeared, and she's been missing since January. So it's obvious to the court, there's nothing I can do here. So I'm going to grant the motion and revoke. Do y'all want to recommend amount of time?
Say what she 4 years.
Defense.
My client, she has 209 days credit, but my client is asking for you to consider reducing that amount to 2 or 3 years, Your Honor. Not to make excuses, but the gentleman that you had before picked up new cases, and he gets 3
So
years.
here's the thing. Let me explain something. And defense attorneys will tell you this all the time. And I used to have clients, they said, well, this person got that. Why can't I get this? Or this person got that. Why can't I get that? I treat everybody as an individual, because guess what? If I didn't treat everybody as an individual, everybody comes before me. And usually, you know what they tell me? Somebody died in my family. I just got a job yesterday. And if I didn't treat people as an individual, you know what I'd be doing? All those stories that people tell me, sometimes they're true, sometimes they're not true, I would hold it against you.
Right.
So what somebody else receives may not be for you.
Right.
So I'm just looking you.
This is a sentencing clinic. Defense asks for 2 to 3 years, citing 209 days credit and life turmoil. The state pushes for 4. The judge counters a classic courtroom argument, but someone else got less. In sentencing, comparisons are weak currency. Judges are required to evaluate the individual. Prior revocation history, compliance risk, treatment opportunities used or refused. Here, the judge lists out every door opened, TAP, mental health evaluation, referral to drug court, and underlines that Alicia didn't show up. That's why the court says, I'm not giving you the minimum. It's not spite. It's structured accountability after earlier leniency failed. For you at home, if the system already tried treatment first and the person vanished, would you still argue for another probation shot?
At an individual, and you're looking at 4 years, because that's your range. And what I can tell you is the person who just came before me, because your attorney brought it up, they didn't have a previous motion to revoke.
Right.
So this is your second motion to revoke. And you're coming before me, and I tried to help you with the MIC evaluation, which is what everybody's saying you need. I already tried that. You didn't want it because you didn't do it. I tried helping you with your drug issue. That's why I had felony drug court. You didn't want it. You didn't show up.
Right.
I tried helping you by giving you a TAP evaluation if you were not accepted in felony drug court. You didn't want it because you didn't show up. So the state is asking for 4 years. Yes, the state is asking for 4 years. Your attorney is asking for 2 to 3 years. What I can tell you is I'm not giving you the minimum because you didn't do anything. And this is your second motion to revoke. So you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Alicia Rubio.
All right, what would you like to say, or defense, would you like to speak to her before she speaks to me, or?
I believe she wants to state why you should give her the 3 years, Your Honor. And I'm going to allow her to speak her mind.
With all due respect, Your Honor, um, I'm requesting your leniency, yes. But I did do my TAP evaluation through Zoom. I did that. I can't pinpoint the exact date, but more or less, it was before the first MTR. I did that through Zoom.
Mhm.
Y'all couldn't find it the first time I came through here, which is why you recommended the second one. Okay, I went through four probation officers, four different probation officers while I was out there. My last one was Mrs. Spence. I did my parenting class that y'all requested. I did my community service. I reported my change of address.
Did you turn in your parenting classes to them?
Yes, I did.
Probation, can you look to see if you have documentation of parenting classes? Go, continue.
I had my sponsor, I gave her my sponsor's information. I gave her
Everyone, please whisper. You may continue. Sorry about that.
thank you. I gave her the information to the program that I was working in San Antonio at Zapata. I gave her all that information. I was doing my meetings at 2:00 and at 6:00 every day. She had no record of that when my paperwork got to her. And I hold myself accountable for missing and not and failing to report. That was my irresponsibility. I agree to that. Yes. My depression was something I couldn't control. I wasn't on my medication. I didn't have the strength to leave my house. You know what I mean? I'm not saying that's anybody else's fault but my own. You know what I mean? I'm trying to learn to hold myself accountable. So I'm doing that. I do have a drug problem, but I have been clean. My drug of choice is heroin. I have been clean off of that since I picked up this charge because my priority is to get back to my mother, especially since I lost my father in March. I want to be with her. I want to grieve with her. I want to do all of that. That's why I'm requesting your leniency.
Alicia's allocution is emotionally honest. She owns the missed reporting, cites depression, the loss of her father, and claims sobriety from heroin since the charge. She also says she completed tasks, parenting class, community service, meetings, and blames paperwork gaps for the lack of records. The judge's reply is the system's reality. Courts deal in proof. Without drug testing or verified documentation, personal claims, true or not, aren't enough to move the needle. The key line: you've been missing since January. That single fact collapses the evidentiary bridge between Alicia's claimed progress and what the court can legally credit. Engagement check. If you were the judge, would heartfelt allocution without verification change your sentence?
You know,
All right, so here's the thing. I don't know if you've been clean or not because nobody's tested you. You're just telling me this.
The last drug test you requested from me, I was here in your court. It was the same thing. You didn't believe me, and I said I was, and you sent me to drug court to drug test, and my drug test came back clean. You know what I mean? I hold proudly that I'm from where I'm from, and I've been clean. That's something I work very hard to do every day. Because as an addict, that's difficult, especially when I'm grieving the father, my father's loss or losing my father. I apologize.
You've
That
been
was nothing
missing.
to do.
Here's the thing. You've been missing since January. So I don't know what you've been doing. That's the problem.
And I take that. That was my responsibility. Again, I'm just asking for your leniency. I want to get back to my mom.
All right, probation. Do you have proof of the parenting classes? All right, this is what the court is going to do. The court is finding violation of 39 true. Court is going to grant the motion. The court is going to sentence you to 3 years in the prison. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Ophelia, Ofelia, Revoked. give you credit for any time served, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, counsel?
Yes, Your Honor.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction and a finding of affirmative violence, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. With regards to the therapeutic community, it doesn't increase the time that you're in custody, but that can help you with any drug issues or mental health issues you may have. Once you're released from custody, if you cannot find a sober living home or somewhere else, just let the court know. If I'm still here, I'll pick up the phone, call somebody to help you, all right? All right, good luck to you, okay?
Final ruling. The court finds violation 39 true, grants the motion to revoke, and sentences Alicia to 3 years in prison. Not the minimum, not the state's full ask. There's a $1,500 fine, time credit applied, an affirmative family violence finding, and a no-contact order with the protected party. Importantly, the judge requests a therapeutic community in custody aimed at substance use and mental health support, plus standard advisals on limited appeal rights and firearms ammunition prohibitions after a felony family violence finding. Takeaway. When courts give extensive off-custody treatment chances and a defendant goes missing, credibility and leniency erode fast. If you found this case as shocking as we did, hit like, drop your take in the comments, and subscribe for more high-stakes courtroom breakdowns. New episodes every week.